A very, very warm welcome to all of my panelists here. We have Michael Will, the president of the Bavarian State Office, I should say, for Data Protection Supervision. We have Dr. Des Hogan, the Irish Commissioner for Data Privacy and the Chairperson of the Irish Data Protection Commission. And we hopefully will be joined shortly by Emily Keaney, the Director of Regulatory Affairs at the UK Information Commissioner's Office. Unfortunately, she has some technical difficulties. We're trying to get her on board, but we should, of course, not waste any time and move forward with our discussion here. It's what our audience has certainly come to watch us for. On behalf of Bitkom and on behalf of all of our members, a very warm welcome to all of you. Thank you for being with us today. Thank you for making yourself available in your busy schedule and in certainly challenging times when the role of data protection supervisory authorities, their role in the new market, their role in the emerging markets, in new technologies, as I know you just addressed this in your keynote a few moments ago, is ever changing, is facing new challenges, new expectations from the general public. And therefore, I really welcome the opportunity to have a little discussion with all of you today on, I would say, 6 key focus areas which our Bitkom members have shared with us and which we know are of great concern sometimes, and certainly of great interest, even if there is no concern to all of us. Why don't we start with the one which is, of course, the most general one, the strategic priorities? And would you like to share a bit on what are sectoral, target-specific enforcement and other strategic priorities that you've set for your respective agencies? These could be related to enforcement, related to counseling, related to new technologies, perhaps also related to certain groups of data subjects like children, or certain groups of technologies like AI, like advertising, any of these. Now, Michael, would you like to kick it off and share with you what the Bavarian supervisory authorities got lined up?
It would be a very easy answer saying, yes, I would like to take it all, but provided I would have enough resources and I wouldn't have to face a situation, and I'm curious to hear what the situation in Ireland is, where we have numerous complaints in this year. What means that we have a rise in the number of complaints that is really astonishing. There is no precise reason for that situation. The only thing I can say is that all my colleagues in Germany are facing the same. And that means, and that reflects a little bit, a strategic necessity. We have to explain data protection better. We have to manage expectations on the one hand of the data subjects, and we have to manage the frustration of the companies that has established in the last months, years, on all those data protection or digital requirements the companies have to face. I just listened to a discussion with insurance companies, say, as well as Bitkom, by the way, are describing a picture where they are frustrated and not longer capable to handle all these administrative burdens or regulatory burdens. And so my issue in the next months will be to handle on the one side those expectations of data subjects, as good as it gets, and on the other hand the expectations of industry and how to balance at the end their expectations regarding competitiveness and innovation on the one hand, and on the other hand the legitimate interests of all of us when it comes to protection of data and fundamental rights. That's for the starting point, I think, enough. I would like to be more precisely, but I would also love to hear about the situation in Ireland.
Yes, indeed. Des, could we bring you in on this as well? Because, of course, many of the major heavyweights, which also happen to be Bitkom members, are regulated by your authority. And therefore, of course, it's very, very valuable to learn your insights into your strategic priorities as well.
Yeah, well, I suppose absolutely, Markus. I mean, first just to agree with what Michaela said. In Ireland, we've had record, as I said in the keynote there, we've had record number of complaints coming in during the summer. Each month, May, June, and July was bigger than the one before, and that was the record. So Why this is, I am not sure. And I imagine this being worked across different countries in Europe. It could be awareness of GDPR. It could be concerns about different issues. But also, I think society, a lot more of our living is happening in the digital world than in the past. I think we are in a time where we are changing into something different, and it's affecting our children now. Um, are more and more their lives are in the digital world than would have been the case even 5, 6 years ago. So that's meaning that society is getting more and more, I suppose, engaged in these issues. Now, whether that's manifesting in more complaints, it is difficult to know, but we will have to reflect on it. The difficulty we have with complaints is that we have to deal as a data protection authority with complaints. We don't have a choice. And the discretionary work we do with our other work, our engagement and supervision and guidance work with companies, if it is an either or situation, that can suffer. But what I want to do just for a moment is take a step back, if I may, and just think about, as your question about some of the larger inquiries which we have been engaged in over for a number of years. So if we go back to GDPR in 2018, in 2018 and 2019, the Data Protection Authority, the Irish DPC, commenced 20 large-scale cross-border inquiries in the first 19 months after the GDPR. So this was a huge, ambitious target. And these inquiries all concern big technology companies and systemic issues and emerging technologies. So there is a lot of work that all this is novel law and all of this is work. Some of these still need to be worked through. But if we look at some of the results that have come from that and from our cooperation with our colleagues, such as Mikel and the other DPAs in Germany, we've concluded many of these inquiries. We've imposed over 4 billion euros in administrative fines, and more important, we have put a lot of corrective measures where companies have had to change things around to comply with GDPR. I think that is much more important than the fines, to be frank. But we've also brought clarity to a number of different novel parts of the law. For example, transparency obligations, transfers of personal data to the United States, transfers of personal data to China, lawful basis for behavioral advertising, children's data protection by design and default for social media platforms, etc., etc. So when these inquiries come through, it like any guidance, it helps set the standard for the industry. But at the same time, we want to I suppose we want to close out these older inquiries and get closer to the curve. We also really need, and some of these inquiries respond to complaints, which we've spoken about a minute ago, but we do also have the space for the engagement. Now, the difficulty we have, I think, as you said, Mikel, is how do we, when we have finite resources as a public body, how do we allocate the right resources to the different areas, particularly when we have organizations, companies who might be frustrated with administrative burden or other things, and they're looking for clarity and for guidance. And that is our challenge.
Yeah, thank you very much for the insight. I mean, it does create a mirror image of what we've been hearing from Bitkom members, because they're affected, of course, in the same way by new technologies where there's a concern, do people even understand their extent and their potential, but also their potential for certain risks. And it's certainly difficult navigating these waters, which I would say leads us nicely into the second question that I would like to offer to you, which is the question of a national difference versus alignment. As you know, it's often been a criticism, well, there are diverging views within the European Union. We're supposed to have a single market. It should all be the same. Why are we getting mixed messages? But then when we ask back, well, are you even getting mixed messages? It turns out the situation is much more differentiated than would first, it would first appear. And so Des, perhaps we could continue with you. How do you see, if there are any, in your perception, the differences in the assessment, the approaches between Ireland, Germany, perhaps also the UK, because you've got vast experience in this transnational cooperation as well.
Yeah, well, I mean, the good news, if I may start, is I'm delighted to say that we had the opportunity to meet Mikel and colleagues earlier in the year in Munich. And when we travel there to meet and have these very discussions about kind of how we work together and what our approach is. And we also had the opportunity back in again at the start of the year to go to London and to have similar conversations with our ICO colleagues there. And that's really important. I took up my mandate with my fellow commissioner, Dale Sunderland, last year, and very important for us to understand and to listen and to engage. So I would say, though, for the cross-border cases, the GDPR does provide this framework for alignment between European Union data protection authorities, and it is very unique. You won't be seeing this elsewhere. When the procedural harmonization regulation comes in next year, which is probably the end of next year, that's going to be supplemented. But we've been learning on the job. We've been learning as we go, Michael, I think, in terms of how we work together. And what we're finding is that the early engagement with our peer regulators is crucial to success. And with early, which is a real priority, certainly of my mandate, the early engagement is really critical. If we can do that, it means that we have more shared understanding, shared common concerns or issues, and we can flush them out earlier on. We've concluded 15 cross-border large-scale inquiries under the GDPR so far. 8 of those 15 resulted in the dispute resolution procedure under Article 65 of the GDPR. But of the 7 that didn't, I'm happy to say the last 5 decisions in a row that we submitted to the Article 60 process went through without objection. And that really speaks, I think, to the enhanced cooperation which we're experiencing. So really, this cooperation, this joint thinking, this understanding the concerns, like in Germany or in England, although I have to say the UK, of course, is not in the GDPR anymore, in the EU, unfortunately. But it really is. It's really important now. It is highly resource intensive, so we do spend time on it, but that's because it's valuable. And I think the whole thing is relationships. You cannot underestimate relationships. But I'd be interested to hear Michael's thoughts on the DPC, and don't hold back, because
No, I mean we're communicating in an open and fearless manner. And before I hand it back to you, Michael, I would like to mention that while no longer technically in the European Union, she is now in the call with us together. I would like to extend a very warm welcome to Emily Keaney, Deputy Commissioner for Regulatory Policies at the Information Commissioner's Office. And it's absolutely great that you're able to join us, because we've already got the first question from the audience lined up, to which we'll get to in just a little second. We were just discussing the question of synchronizing the supervisory authority. As you know, that's what our panel is called. And we were going to get a view from Michael to see, well, does he share Des's assessment? Are there any other perspectives you would like to add? And then, of course, Emily will extend the same question to you as well.
Yes, no wonder. Everyone says there are so many differences between European data protection authorities, and I just show you the real picture today. We agree. We look at the same picture, and even in the role of a concerned supervisory authority in many cases, I can precisely underline what Des said. We now know the value of alignment, and we are ready to invest time. We are ready to understand the specific conditions of each case. Every case is different. That's necessary to accept. We don't have this, the situation of policemen going through the roads and looking at cars which shouldn't be parking there. We have very complex cases, and we have to invest resources and times to understand them. Once this we succeeded on that point, it's easier to come to an agreement and to avoid indeed all those discussions we had, all those escalations we looked at on EDPB level. That's also an advantage for us, because every case is something which we learn. We learn better the different approaches of our colleagues, and so it's really for everyone valuable looking in the database provided by all those cooperation cases. It's case law that gives you very, very precise ideas of our discussions and of very peculiar topics that Death mentioned when he referred a little bit to his very admirable results in the last months.
Thank you so much. And of course, it's very timely, Emily, that you are here, because I would really like to get your view on this. We've already said there's a bit of a status change, of course, the UK having left the European Union. Would that affect the cross-border synchronization and the cooperation at all? What is your perspective on how this has evolved for the UK?
Yeah, and firstly, apologies for being late. There was a bit of a time mix-up at our side, so I'm really sorry about that. Obviously, that change in status affects some of the mechanics of the cooperation. You know, it is inevitable, but actually cooperation is still incredibly important to us. It's still really high on our agenda. You might have seen recently we did joint enforcement with Canada on 23andMe, and we do that. We have memorandums of understanding with DPAs across the world, including in Europe, which includes thinking about how we might cooperate in this sphere. But I think the other thing to say is that for us, it doesn't just have to be formal cooperation either. So actually being able to sort of share our priorities with other data protection authorities, share how we are thinking about the landscape, where we think the risks and the opportunities are, that kind of ability to kind of work together at a more strategic kind of level and thinking about what the landscape looks like and where we might focus our attention is also a really important part of that broader cooperation picture. And actually all of us as data protection authorities have limited resources, and enforcement is often quite complex. So I think the other aspect to cooperation as well is understanding, do we all necessarily want to be focusing our attention in the same area, or can we make change more effectively if we're thinking about, you know, whether some data protection authorities are better placed to focus on some areas than others. So I would say that it's really crucial for us. We do that formal cooperation, and we do formalise the way we work with other regulators through MOUs. But we also think of it as part of a spectrum around sharing information, thinking about priorities, kind of more broadly helping each other in terms of understanding that landscape.
Thank you very much. And I think it nicely aligns with a couple of the other items we've already talked about. And it really does lead us to the question, where do the data protection supervisory authorities place themselves in the context of all these new laws? We have the Digital Services Act, we have the Digital Markets Act, as you mentioned it a few moments ago in your own keynote. We have the Data Act, of course we have the AI Act. All of that calls, as it's already written in the Acts, for supervision, for orderly supervision. And how do we ensure the data protection supervisory authorities find their place and find their role in these proceedings? And Emily, since we last heard from you, perhaps this is something that you would like to take us on a little journey of how you would be seeing, although of course these regulations do not directly affect the UK, but indirectly for sure, they will affect it just as well. How do you see that perspective? I wouldn't call it an outside perspective, but just a perspective of an independent third party perhaps. And then I would like to hear from Michael and from Des as well, of course.
So I think obviously the context for us is slightly different, but actually the themes that you touch on there are the same. So in the UK we have ongoing debate about what future AI regulation will look like, which is informed by the approach that's been taken in the EU as well as elsewhere. We also are a member of the Digital Regulation Cooperation Forum, and that includes work together with our competition regulator as well as the kind of online safety and communications regulator and the financial services regulator, which I think reflects how increasingly interconnected these kinds of themes are. And it's a really important both for us and for the organisations that we regulate to help navigate those themes. And we see actually in the organisations that we regulate, people who were previously just responsible for data protection, now being responsible for AI compliance, both in the UK and in Europe, and for thinking about the ways in which these different types of legislation overlap. So the mindset and the thinking in the organisations we oversee is also really informed by that landscape. So I think we face very similar questions. The other thing that I think is important to say is that even where you have separate AI legislation, the fundamental data protection principles around the way in which data is used in those systems continue to apply. You know, it remains still about what protections you have in place for the personal data, how it's being used, the transparency. So even in that kind of complex landscape where you've got different people taking on responsibility for different elements of it, there remains that underpinning thread of what's happening with the data, which means that the Data Protection Authority will always have a role in that ecosystem.
Well, thank you very much, Emily. And I would assume much of this resonates with you, Michael, as well.
Yes, it's completely in line. I have quite similar perceptions. I think this is due to the technology we are trying to regulate. It's not a question of the regulatory concept behind our work. It's the question how we should deal with AI in a democratic society based on rules, not on some ideas. And so cooperation of different experts will be the key issue and the key task for all of us who have to deal with those digital topics, with these digital laws, which we established at least in the European Union in the last years. I would hope, by the way, that the German government comes to the same analysis, and I hope somebody of them is listening to Emily and perhaps also to Des. What means that in Germany we are not already exactly in the situations that Emily described, that we have the idea or the goal at least to establish a structure like a board where every entity which is responsible for an element of AI comes together and shares information and analyzes and then comes to a common conclusion what to do or to say on that project. This is sad, but I hope all this input of Bitkom will inspire us a little bit.
Well, it did do that in the past, I'm proud to say, and I'm also proud to say when we come to talk to the supervisory authorities and they come to talk to us, they talk to us, they listen and we listen. And so this is why we have formats like this one today. And Des, I know you've been on our panels quite a number of times. I would not assume you have any diverging views on the future of this cooperation and where it leads you strategically with all these new legal acts. Would you share this perception that there's a regulatory tsunami that's increasingly difficult to navigate? And how could your authority make it easier for whoever needs to apply these laws to do that?
Yeah, I'd agree with what Emily and Michael say. First of all, the GDPR will still apply, particularly as Emily said around transparency, lawfulness. You know, those kind of fundamental questions about accuracy, data minimization, etc., etc. You know, we set up a new function last year on interregulatory cooperation, because we've already started cooperating and co-regulating with our peers, you know, where we have responsibility for different areas. And there's no doubt when we meet companies, they say that back to us. They say, look, what is happening and what is going to happen, the AI Act hasn't fully come into effect yet. So from the regulator's point of view, we want as much as we can. And like Emily, in Ireland, we have a digital regulators forum where we meet with the other regulators so that we have kind of common approaches, and we have a formal structure into government as well in terms of what the big themes are. And a lot of it is around I suppose the staffing of the regulators in terms of the the knowledge, the skills, the technology, the technologists we need to be able to give that really efficient service so that companies can come, they can engage, and they can go out and they can kind of go into a sandbox or whatever we want to say. We have been regulating AI for the last 2 years, so we're in that space already. We've seen the European Data Protection Board have a coherent view on in its AI opinion last December. We've been implementing that since then. The ICO has something similar last December. It has set out its opinion. So, we are, as DPAs, trying to get ahead of the curve, and we're trying to kind of stand in the shoes of the organizations to say, what would you like? What would you expect when you see the regulator? At the same time, we do enforcement. We have started inquiries, one into Grok, into X this year. We started inquiring into Google PAM from last year, cross-border inquiries, and talking to our peer regulators. When it comes to the AI Act, AI Act is going to it's going to apply all sectors of society again. So, if I'm a regulator for aircraft, why would you make the Data Protection Authority the regulator for the aircraft using the AI, unless it was a prohibited practice or it was a high-risk practice or something like that? So our authority we will have a role under the AI Act. I can't tell you now what will be because the government hasn't announced it, and I want to be respectful to the process, the parliamentary process in Ireland. But we are already planning for that, and but with the Digital Services Act, the Digital Markets Act, we're already in that co-regulating space. I think collectively across competition authorities, across online safety authorities, we just need to probably continue to improve so that we can provide that I suppose innovation friendly environment for the organizations coming to us.
Well, thank you very much for that. And I should, for the benefit of the audience and for the benefit as of yourself and of Emily, perhaps clarify one little in-joke that Michael made just a moment ago. It referred to a discussion we had yesterday on the first day of our privacy conference, where one of Michael's colleagues, a data protection commissioner for one of the German states, was, I should say, moderately impressed by the fact that he had read in a recent draft legislation, which always includes the underlying reasoning and is officially gazetted so everybody can review it. The concern, can data protection supervisory authorities really be trusted with innovation, or isn't that exactly the opposite of what they're doing? And so this, I would say, was this little reference that may have flown under your radar just a moment ago, but it made for a very interesting discussion. And I would say, we have quite a few interesting concepts, and it's awfully fascinating to see all of your insights here. Now, before I go for one final round of very, very brief statements on the future outlook and what you would like to do next, we've got a couple of questions lined up here. The first one is, and this is really an interesting one because we did discuss it yesterday, what is the European view? And in that, I take it to mean the European Union or European Economic Area view of the UK ICO's practice, which I would summarize, Emily, and I will gladly stand corrected if I'm misstating facts, but I understand the practice to be that when there's a complaint received, first, the controller or processor against which it is directed gets an information from the ICO and says, well, we've got this complaint, kindly sort it out if you can, because if you don't, we'll be forced to intervene. And there's a lot to be said about that approach, but of course I'd like to get your understanding, Michael, perhaps first, and then also Des, and of course, Emily, if I was misstating things, then that, of course, I will gladly stand corrected, as I said.
Okay.
I think I would just clarify that sure. we definitely try and make sure that complaints go to organisations first, but it's not a requirement. So, and there may be circumstances in which that's not appropriate, and it's too difficult or the individuals are vulnerable for some reason, but it's definitely what we encourage because we think it's quicker.
Yeah. So it's a bit of a discretionary approach.
Yeah,
and, very good.
Yes, I would love to see that it's not only encouraging the data subject, but that would be, even in European law, a requirement. And that leads to the task that I see for the next month. We have to advise and take him by the hand, the European legislator, when it comes to the question of how to, yes, go forward in terms of should we have GDPR 2.0? Should we amend certain topics? Should we have additional laws on AI and others? This is a question that is, I think, now crucial, because we have, at least in Europe, those discussions coming from the Draghi report and others. And now there is a window of opportunity to address some key issues that would provide us some room for discretion, some room for strategic decisions on what we do or what we wouldn't like to do, and would, on the other hand, even give these simplifications to the companies which ask for that very, very harshly and are afraid of their competitiveness. I think that is up to us to give that advice, because we are also applying this law, and we have some necessary insights to balance the different interests, to have an effective law on the one hand and a protective law on the other hand.
Very good, thank you. And Des, is your view the same or diverging? Do you have other priorities, perhaps?
Yeah, well, I suppose just on the question of how we deal with complaints, I mean, we would usually kind of send them to the controller to get their response or to see if they can be sorted out. I mean, a lot of the complaints we get are very, can be, if they're low-lying complaints, like, my account is blocked or something like this. I mean, the irony is that sometimes it's for a CSAM reason or something that the individual isn't being told about. But they again, that moves into a policing matter. But but we don't always do that. I'll give you an example. Recently, we had a protected disclosure, and it was on the basis of a National Children's Hospital. So we did an unexpected inspection, unannounced, and we discovered matters, and then we've opened an inquiry on the basis of what we discovered. So there you would not necessarily look for an immediate response, but you would try to find out the information yourself, and then you would take an approach, an enforcement approach after that, depending on the severity of what you find. So it really differs, but of course, with all the different complaints coming in, and when the numbers increase, you start working with backlogs. And the worst thing about a backlog of complaints is that because you're working it becomes more historical as time goes on. It's less likely to be resolved. So the more companies and controllers can deal with complaints that come in, but very simple things like subject access requests really should be dealt with by the company. There should be no reason that's going to the DPA, because that begins to clog up the system. And then also trying to differentiate between, is it a personal data issue, or are they are people trying to use the GDPR for other reasons, employment reasons or dispute reasons? And that itself means a triaging of the issues early on. So again, this all eats up into resources. So that would be our general approach.
Thank you very, very much. Thank you for all of these interesting insights. You've already shared your outline of what you see in store next for us, for your agencies, for all of us, for the data subjects, for the controllers, the processors. It's always a very welcome exchange we have with you. I hope we'll have many more of these formats, because they're incredibly productive, very transparent, and do much more for getting mutual understanding than exchanging briefs or memos or written communication could. Thank you very much to our panelists. Thank you especially Dr. Des Hogan for your flexibility in adjusting your schedule. Thank you very much, Michael, for being here in the studio with me today. Thank you very much, Emily, for your fascinating insights, for not shying away from the difficult topics. And I should say, viewers should definitely stay tuned, because Emily Keaney is actually going to be on next with her keynote on very fascinating insights into the machine room of the Information Commissioner's Office. You heard it here first. Do stay on for the rest of the day and enjoy the rest of the Privacy Conference, and do return frequently. Thank you very much.